Okay, this is BBC Technologies LLC versus Raywall Agro Tech Foods Limited, docket number 19-873CB. This is the time set for 3 motions for summary disposition. We've got the plaintiff's motion for summary disposition as to the plaintiff's complaint, and then we've got cross motions for summary disposition on the counterclaim, the plaintiff's motion, for summary disposition under C10 as to the defendant's counterclaim, and then the cross motion for summary disposition by the defendant on their counterclaim. And this has been extensively briefed, and I would like to do oral argument with all of these together as one big oral argument. And you all filed on the same date, so I'll just let the plaintiff go first. And first, though, I'll take all your appearances for the record.
Thank you, Your Honor. Good afternoon. This is Joe Vernon for the plaintiff, BBC.
Thank you, Your Honor. Colin Neihold.
Oh, sorry, Colin.
I apologize.
Anita Marinelli on behalf of the plaintiff, BBC.
And Colin Neihold on behalf of the defendant, counterplaintiff, Raywall Agro Tech Foods Limited.
Okay, thank you very much. Mr. Vernon, you may go ahead.
Thank you, Your Honor. And I know the court has read the brief, so I'd just like to outline why we believe we're entitled to summary disposition on our claims and the counterclaims, and otherwise just address a few of the items referenced in Raywall's reply. We believe we're entitled to summary disposition on our claims. Well, if we start with the contract claim, the relevant facts are not in dispute. They rented 5 machines. They received all 5. All 5 were delivered and working as of July 17th, 2017. This is something they admit on page 26 of their brief, but they never paid for them. And I understand that concerns have been raised in this suit that 3 of the machines weren't working until July 17th, and there's an argument that was that Raywall has made that was late and that there were service issues, but those concerns were resolved unequivocally by way of a credit. And we've reflected that credit in the amount we're seeking in this case, and it reflected in all of our invoices and statements of account. And since we're speaking about invoices, that brings us to our account stated claim. And there's no dispute that they received the invoices and statements of account. May 7th, July 11th, August 19th, October 8th. Those invoices did reflect the 18% contractual interest rate. And there's no dispute that they didn't object. Mr. Raywall conceded, and we detail this on pages 7 and 8 of our brief, that neither he nor Mr. Frazier ever objected to these invoices. In fact, and this is an important point, we feel, they promised to pay them 4 separate times. They promised to pay them as late as October and December of 2018 and March of 2019. And I mention those dates because that's long after these issues that they're allegedly complaining about. And we have the affidavits from Mr. Neville and Mr. Larson, who were the 2 folks that were the primary interface with Raywall. And we have their contemporaneous emails. And when Mr. Raywall was presented with these facts at his deposition, he said, in particular, that he promised to pay. He said, fair enough. I'm not going to suggest that Ryan was lying when he sent the confirming email saying, I just spoke to Mr. Raywall and he promised to pay. So we feel there's no genuine dispute on either of those claims, and we're entitled to recover under either theory for the full amount of the invoices, which is $144,000, and the contractual interest rate, which is $67,249 as of today's date. We did include in our Exhibit X the calculations. And that comes to a sum total of $211,249.97. Raywall takes issue with the fact that we didn't seek the consequential damages. And I believe it was the last time we were before the court, we filed the motion to amend to reflect the fact that we would be seeking consequential damages at trial. We felt the proofs on that issue seemed to require a trier of fact in terms of whether we could have and had the opportunity to remove the machines and the number of the damages. It just did not seem something that was appropriate for an SD motion, which is one of the reasons why we didn't assert those claims in the SD motion. But in terms of the fraud claim, which we discussed adding in the motion to amend, and our concern at the time was that there were a number of promises made to make payment, and we believed that those promises were made not in good faith or to make the payment, but just to keep the machines on site. The court had some concerns about adding that claim, if the court recalls, and warned that the parties better have solid evidence of the intention to defraud. And we heard those concerns and decided against adding that claim. But those concerns, I think, provide a good segue to their primary defense and their counterclaim, which is this fraud argument. And as we get into more detail in our briefs, Raywall, they had to identify an actual and specific statement that was made by somebody at BBC. They had to identify the individual who made the statement and the specific context of the statement. We talk about that on page 4 of our brief in the 5504 Reuter case. This statement couldn't be a matter of an opinion or just sales talk, whether something is better or whether something is enough. We talk about that on page 7 of our MSD. And it could not be about a future promise. The case law says those are contractual. The alleged fraudulent statement has to relate to a past or existing fact, and that comes from the Van Tassel case we cite. So finally, in the face of a merger clause or an integration clause, the statement had to be the type that invalidated the entire contract. So it either tricked Raywall into believing that the statement was part of the contract or that Raywall wasn't signing the entire agreement when it was. And I run through those 5 points because their fraud allegations don't meet any of those standards. The allegation from the complaint is that BBC made plaintiff believe it had machines and personnel in BC, and that they had local service technicians who would attend to maintenance and troubleshooting. And as we detail in our brief, what BBC says it believed is not relevant. They didn't identify a statement or a speaker. And whether they had a local technician available during the term of the contract is a future promise. But as we also explained, it was also undisputably true. Mr. Raywall acknowledged, yes, they had at least 3 or 4 service people on site, and the service records confirm that these people were there regularly. So the bottom line here is that the allegations in the complaint didn't get it done. But we also asked Mr. Raywall specifically in his deposition, what specifically did BBC say to you? And we reference this on pages 4 and 5 of our response because there's an extensive discussion. And essentially what he says is they told us they had staff on site, meaning on the ground in British Columbia, and that they had this set up in British Columbia. And again, these are statements about future conduct, but they're, again, also indisputably true. Mr. Raywall acknowledged they did have staff on the ground in BC, and they did provide regular service and maintenance, and the records reflected that. So all of this argument goes to the sufficiency of the statement, which is just sort of the first hurdle that Raywall would have to establish on the fraud counterclaim and defense. But in addition to being insufficient and untrue, there's no misrepresentation. There's no dispute that there's no evidence of fraudulent intent. And Mr. Raywall actually discussed in his testimony the fact that he didn't believe there was fraudulent intent, that this is the type of thing that could happen to anybody. And there's no dispute that they didn't rely on the statements. He talked about the fact that where the machines came from didn't matter, whether it was the US or New Zealand. And he knew that the service staff was being imported because that's normal for that industry. So, and finally, again, we had the merger clause and none of the allegations were of the type that could invalidate the contract. So what we're left with to discuss is the claim for breach of contract. And as we lay out, there isn't, and Mr. Raywall acknowledged in his deposition, there's nothing in the contract that speaks to an obligation to provide the services that Mr. Raywall was complaining were not provided. Not a single provision that does that. And this is not a breach of warranty claim, which is something that Raywall has acknowledged a few times as well. So in light of that, they haven't identified an actual breach. What they're claiming the problem was not a contractual obligation. And again, the contract also made clear that BBC wouldn't be liable for delays attributed delays attributable to transportation issues or for consequential damages. So even if they could identify a provision that was breached and admit that they haven't, their claims are barred by the merger clause, the exclusion of liability for delays, and the exclusion for consequential damages. So that's probably more of an overview than the court wanted or needed. I apologize, but unless the court has questions, I'd just like to conclude by reiterating our ask, which is that the court grant summary disposition on our breach of contract claims and or our account stated claims. It's the same amount sought and proven in both claims, and enter judgment in favor of BBC in the amount of $211,249.97, and dismiss Raywall's counterclaims with prejudice. Thank you, Your Honor.
Thank you. Mr. Nyholt?
Yes, Your Honor. Since this was pointed out in the briefing, I would first like to move the court to accept my over-length brief. It was approximately 11 pages over the 20-page limit. I'd like to move for acceptance of that brief.
Well, you already filed it. You're supposed to do that before you file it. So I'll have a thing to say about that. Go on.
Mea culpa, Your Honor. I do apologize. And you're correct. That should have been filed with me. I will acknowledge that error on my part. Your Honor, but getting down to the, what we're really here talking about, which is the merits of the claim, at the end of the day, what this boils down to me is BBC's consistent and repeated failure to do what it was supposed to do, which was to provide working machines to Raywall. In 2017, they were supposed to provide machines that were supposed to be provided by a certain start date, and they weren't. When BBC's service staff shows up, they show up without tools and without parts, and they can't get the machines fully operational. Raywall ended up losing, by its records, 1.4 million pounds of processing capacity that year over the year before when they were using a different vendor. After this happens, Geoff Furness and Mr. Raywall, had kind of a reckoning, a string of emails between them. You've, I'm sure, read all of the skinny on that, but the bottom line is Raywall says, tell you what, we want a big credit for 2017 because of how bad you guys messed up. And we'll pay you and we'll keep you in 2018, but we want assurances from you that this is going to be done better. Mr. Furness responded with his statement in writing that, yes, we are increasing our capacity and bandwidth in British Columbia. Based on that, Raywall enters into this payment agreement that you've heard them talk about to pay 15 grand from the previous year. This was a $49,500 credit over what they had agreed to pay originally on a $129,000 bill. That'll show you how bad the error was with BBC, that they were willing to give them a nearly $50,000 credit on a $129,000 bill. Well, 2018 didn't go any better. Raywall, the machines aren't working. And, it's interesting to me that BBC claims that it's false that the machines weren't working because there's no emails between them, when BBC admits that the process for asking for help was for Raywall to call their service techs on their cell phones. I mean, talk about a haphazard way to run a business. Instead of having a centralized place where a customer would call and, get help, they're just supposed to call the service techs on their cell phones. And Mr. Furness acknowledged that, that they're not even required to keep complete and accurate records of all of the calls that they receive. So, BBC, the only way they counter Mr. Raywall's clear and explicit testimony about these non-working machines is to point to the absence of emails. Well, we know he was supposed to call their cell phones, not email. And because of their lack of records for these calls, when they're not required to keep complete records of the calls. What Mr. Raywall has given you for the 2018 continuing failures is not only his own testimony. He gave like 4 pages of solid testimony about, this machine wasn't working. This is the ones that they were supposed to run. He had 3 pairs of machines. Only 1 pair was working. And then there was another different kind of machine where one of the 2 machines were working. You're nodding your head, so I see you apprehended that part of my brief, so I don't want to belabor it. I gave a visual representation of it to kind of lay out what each one was supposed to be charged for. At the end of the day, I mean, if it became an account statement because Mr. Raywall didn't email them back and say, I object to this payment because you guys didn't complete the machines, apart from calling the service techs and having them ignore his calls for service, we can still challenge under the account stated the charges. $129,000 of this charges is for about $79,000 worth of working machines they never produced. And as for Mr. Vernon's statement that the contract doesn't require them to provide service or working machines, yes, it does. I mean, Mr. Furness himself acknowledged in his deposition that in one of these rentals or leases, whichever he would refer, his accountants would tell him to refer to it, he was responsible for providing the service to these when they were in fault recovery, and they just did not. So if nothing else, I mean, there's room to differ. We've raised arguments. I mean, really, the fraud just goes to whether they can enforce this limitation on consequential damages that resulted from their failure to keep the machines working or not. And really, that's what fraud does. It gets us past the integration clause. Even if not, I personally think that the paragraphs as worded aren't as inclusive of the claim for consequential damages as Mr. Vernon would have us state. Because number one, we have the paragraph 8 is this limitation on warranties, which is contrary to Michigan law. That such a which is written because it's not bolded, it's not set apart, it's not stated as a waiver of warranty should be stated. And number two, reading the consequential damages waiver in that, it's in the same sentence as the warranty claim. So I think it's fair to say that it's a waiver of consequential damages in warranty claims. The only other paragraph in the contract that anybody has cited that speaks to consequential damages is this limitation for acts of war and failures, which doesn't list losses because they fail to provide service or setup, which was also part of the contract. So I think really none of the language in the contract that actually talks about consequential damages speaks to this particular circumstance where we've had a consistent failure to get the machines running and provide fault recovery like they were supposed to. And that's why I think it would be appropriate, even if we ignore the fraud, even if we ignore what Rochelle promised that they couldn't deliver at the beginning, there ought to be we ought to be able to get past the consequential damages and receive some recompense for the significant losses that Raywall had here. I mean, 1.4 million pounds of processing volume in 2017, an amount approximately that in 2018. This was a staggering loss based on BBC promising something it couldn't provide, service and working machines. The only other piece I'd like to talk about here is this $750,000 claim that they came. I mean, first we called it punitive damages. Then the other side finally found out that Michigan law doesn't allow punitive damages, so we called it fraud. Then you threatened them with sanctions for the fraud claim, so they don't call it fraud, but now they're calling it lost opportunity claims. What they're saying is that they should have been able to take these machines that were sitting in Raywall's facility, lease it to somebody else in the off season, and lease it to somebody else again in the off season. I asked Mr. Furness, he couldn't identify a single time he'd ever actually done this. And Mr. Vernon's redirect questioning, he said, well, we can release it a second time, maybe about 40% of the time, and release it a third time about 10% of the time. So the 750 is based on, number one, getting double recovery for every year that Raywall was supposed to pay, even though they didn't provide working machines the years that Raywall was paying, but also leasing to somebody else and then leasing it to somebody else again, not double, but triple dipping. And, what really kills it in their mind, and why I'm amazed they're actually arguing for it, is that Mr. Furness acknowledged that between 2017 and 2019, they made no attempt to reacquire the machines and do this because of quote unquote further problems with the account. I've not heard any argument from them even now how they would get around a failure to mitigate in that circumstance. And as for after 2018, they claimed that the only reason they said they should get it for 2018 is they had to repossess the machines because Raywall didn't pay. Well, to move them to the second site and the third site, they'd also have to repossess them. So how is that Raywall's fault? I mean, whether they owed him money or not, it's on them to come get the machines. There's no attempt here to do so. So I see absolutely no reason why they'd be able to get to $750,000 in damages, because none of their inability to release these machines down the road is attributable to anything Raywall did. Unless there are any specific questions, I don't think I have anything further.
Okay, thank you. I'll just give Mr. Vernon a brief rebuttal if he wishes.
Sure, Your Honor. Very brief. As I explained, all the 2017 issues were resolved by way of the credit. As we explained in our brief, if Raywall is saying the credit was never agreed to, I don't see how that's helpful for them, because what that means is that's an additional $50,000 added to the claim while their claims are dismissed. Regarding Mr. Furness's proposal, Raywall specifically rejected that, so relying on Mr. Furness's email shouldn't work. And there's no dispute that in 2018, and the sole allegation they're left with is that 2018 could not be a repeat of 2017. If that were certain enough and became part of some agreement, and it doesn't, because the 2017 agreement is the one that still governs, it's still undisputed that 2018 was decidedly better. The machines were there at the beginning of the season. And by Mr. Raywall's own testimony, the service folks were there, and the year started off very well in 2018. So there certainly wasn't a repeat of 2017. The service records do not speak to the issues that Mr. Nyholt is complaining of. And just to briefly address the conspicuousness argument, which we do in our briefs, consequential damages do not require the conspicuous bolded language, and the use of the word "or" in that paragraph we feel is definitive for the reasons we explained in our briefs. But that's all I have, Your Honor.
All right, thank you. So I'm going to start first with the cross motions on the counterclaim. That's really the more involved of the two. So first of all, I do want to say that I read every word of all the briefing. I read it more than once, and but I still have to give a mild scolding here to Mr. Nyholt. His brief was 32 pages long. I never granted leave, and I wouldn't grant leave for 32 pages in a case such as this. Attorneys often think, well, it's very fact-driven or something, but when you read the brief, there's plenty of wasted pages. I mean, you don't have to wait, and this is a mild scolding in case we meet again. You don't have to waste pages arguing about things that aren't pertinent to the court's decision, like issues that weren't raised by the moving party. I never heard Mr. Vernon ask for a judgment in the amount of $750,000 with respect to this particular motion or set of motions. You don't have to argue about whether a deposition was contentious or not, or who was deposed and why or why not. So you take out all those extraneous things, and I may have granted an extension of the page limit, but I wouldn't have gone to 32 pages. And I do it in advance because then I like to offer the other side the same courtesy. So in the future, that's how it works. Also, the defendant requested in their motion for summary disposition or directed verdict under MCR 2.504B2. That's a rule that applies to a bench trial where the court's heard all of one side's the plaintiff's evidence. That is not applicable here at all. So these are just cross motions for summary disposition on the counterclaim. And then finally, I just want to clarify, because the defendant cited a standard for summary disposition where the court resolves factual disputes in favor of the non-moving party. And I agree, the case cited does have that language, partly because it mixes together the directed verdict standard as well. But I can't resolve factual disputes on a motion for summary disposition. The applicable standard, and just for the record, the standard that I'm applying is, I look at, if it's a C10 motion, I look at all the affidavits, depositions, documents, whatever's been submitted under a C10 motion, and I look at it in the light most favorable to the non-moving party. That doesn't mean I resolve factual disputes, but I look at it in the light most favorable to the non-moving party. I determine whether there's a genuine issue of fact. That's something upon which reasonable minds could differ. But if it's a matter of law, it's decided as a matter of law, and an unambiguous contract is enforced as written. So those are the ground rules. Moving on then to the counterclaim. Count one of the counterclaim alleges fraud. The allegations in the counterclaim of the false statements are, first, that the machines were in British Columbia and would be delivered soon. Second, that local service personnel would respond to calls promptly. And third, that a service person would be out for the 2018 season to refurbish and prepare the machines. First, none of these allegations, as they appear in the counterclaim, meet the specificity requirements for fraud allegations. The affidavit of Mr. Raywall that is attached to the counterclaim does no better. However, the specificity rule is a rule of pleading. It's not a rule for deciding motions for summary disposition. And it's apparent to me that the pleading deficiency could be corrected based on the deposition testimony of Mr. Raywall. So for purposes of this motion, I will assume that if the defendant amended the counterclaim to comply it would do so consistent with Mr. Raywall's deposition. And by that, I mean that the promises alleged to have been made before the contract was signed were made by Paul Burchell, and the promises made prior to the start of the 2018 season are contained in the email chain that is Exhibit M. So first, dealing with the statement that the machines were in British Columbia, that can be disposed of immediately because Mr. Raywall testified that where the machines came from was irrelevant to the defendant. Fraud requires reasonable reliance on the statement, and Mr. Raywall, by his own testimony, did not rely on any statement about the origin of the machines. The next alleged fraudulent statement is that the machines would be delivered soon or that they would be delivered by a certain date. Taking this allegation as true, that the defendants were promised that the machine would be delivered by a certain date, it cannot support a claim of fraudulent misrepresentation. Statements or promises of something to occur in the future cannot support fraudulent misrepresentation or fraud, unless it can be shown that the statement or promise was factually false at the time it was made and that it was known to be false. We know this isn't the case about the delivery of the machines, and we know it again by Mr. Raywall's own testimony. And we know that it wasn't false and known to be false at the time, is what I meant to say. And we know that from Mr. Raywall's own testimony. According to Mr. Raywall, he acknowledged that that plaintiff didn't know in advance that there would be a delay. He said, Mr. Raywall said, that they had been counting on the machines coming from a processor in British Columbia, but the processor in British Columbia refused to let go of the machines, so they had to be shipped from the United States. Now, Mr. Furness had a slightly different reason, but it's a reason that still had nothing to do with any action taken by plaintiff. It was something in the future that would have been unknown to the plaintiff at the time of making the statement. So Mr. Raywall acknowledged that the statement was believed to be true at the time it was made and that it subsequently became impossible to achieve. That can't be fraudulent misrepresentation. The same thing occurs with the last two remaining allegations of fraud, that local service personnel would respond promptly to calls for service and that a service person would be out for the 2018 season preparations. And by the same thing, I mean, first, according to Mr. Raywall's testimony, both allegations cannot be shown to be factually untrue at the time they were made. And both allegations are promises of something to happen in the future that can't support fraudulent misrepresentation. Again, without evidence that they were actually factually false at the time they were made and known to be false at the time they were made. They were promises of the future or predictions of the future. A service person will be out. Even to say that they'll be out in a half an hour's time is still a statement about something to happen in the future. There is no evidence here to show that it was known at the time to be factually untrue. There also, with respect to service people being local and responding promptly, Mr. Raywall had to admit that there was a British Columbia service team, something that Mr. Furness also testified to. He said that, you know, they were transient, but they were there. And there actually is no, and this really isn't necessary to dismiss the fraud claim, but there was really no evidence that they actually failed to respond to calls. The most that Mr. Raywall could say about failing to respond to calls, and I read his deposition in full more than once very carefully. He said, quote, "we," end quote, called them numerous times and they didn't show up. The defendant says that's enough, but I disagree. And this is a C-10 motion. It has to be met with admissible evidence. That testimony from Mr. Raywall didn't even establish that he's speaking from personal knowledge when he says, "we called numerous times." Who called? You or someone else? If it was someone else, did you have firsthand knowledge or did someone tell you? When did this occur? What time frame are you talking about? His testimony was vague and it lacked foundation. Hearsay is not admissible in opposition to a C-10 motion or in support of a C-10 motion. But that's really beside the point. The main point is that these are promises of what's going to happen in the future, and that evidence is lacking to show that it was factually false when made and known to be false. So these are all statements about future events that can't support fraud allegations. I would back up a little bit, going back to this issue of Mr. Raywall's complaints about what happened with regard to service and what he did have knowledge about. There was one specific complaint that it appeared that he did have knowledgeable testimony about, and that is he said that when they showed, they didn't have the necessary tools or parts to service the machines. And with regard to the 2018 service preparation, he ultimately had to acknowledge that 2 people showed up to service the machines on the date they were expected. But his real complaint was that out of 40 or so belts that had to be replaced on a machine, each machine, they replaced several, 2 or 6, or just a very small number of them. But in the end, even taking all of his complaints that he had about the service that he appeared to have firsthand knowledge of, that he described in his deposition, again, this is not fraudulent misrepresentation. What he's complaining about is bad service, that he believed was bad service, that slowed his business, allegedly cost him money, and was not in line with what he believed that he was paying for. And I want to be real clear. I'm not saying that I think he's wrong. I'm just saying that none of these statements can be the basis for fraudulent misrepresentation. And there's another reason why they are not fraudulent misrepresentation, and that is there is a contract that sets forth all the terms of this equipment rental. Paragraph 9 provides quote, these terms and conditions shall supersede any provisions, terms, and conditions contained in any conformation order, verbal agreement, or other writing the buyer may give or receive, and the rights of the party shall be governed exclusively by the provision, terms, and conditions hereof, end quote. Now you can call that a merger clause, or you can call it an integration clause. I'm not sure which one we want to call it, but it really doesn't make any difference. None of these promises that the defendant complains about are in the terms of the written contract, except maybe the delivery date, which I'll get to in a moment. But none of them are in the written contract. So the question is whether the merger clause can bar the fraud claims. And plaintiff cites the UAW GM case. That case is discussed and explained further in another case, Barclay, BARCLAE versus ZARB, ZARB at 300 Mishap 455, a 2013 case where the court talks about UAW GM. And the court asks, so when does fraud invalidate an entire contract, and when is it such that it provides no remedy or recourse if there is a written contract with a merger clause? And in partial answer, the court cited Restatement Second of Contracts. If a party agrees to a contract based on a fraudulent or material misrepresentation that they were justified in relying on, then the contract is voidable. A merger clause can render reliance unjustified as to agreements related to performances that are not included in the written agreement. So example, and this is loosely based on that case, if you were selling your assets and you failed to tell the buyer that a particular asset they were interested in had already been sold, then there may be fraud even in the face of a merger clause in the sale contract. But if you're promising something that just adds to or varies or contradicts the terms of the written contract, then there really can't be any justifiable reliance on that promise when the contract terms differ and the contract contains a merger or integration clause. So that's what I would apply here. The defendant wanted better service and relied on promises of service, but all the terms that the defendant wants to govern this equipment lease could have been put in the equipment lease, and they were not. Or the damages are negated, and that's another thing I'll talk about in a moment. So it's just not justifiable reliance or reasonable reliance to believe that any promises made pre-contract about the terms of the contract, when those terms are not in the written contract and the written or contradicted in it, and the written contract contains a merger clause, that just cannot be justifiable or reasonable reliance. One of the problems here is that Mr. Raywall testified that he didn't really read the contract that he signed. He testified that he didn't go through the details of the contract. He paid more attention to the price than what he called the fine print. So while his expectations may appear reasonable on their face, if you read his deposition, it seems reasonable. They were not the terms that he agreed to in writing in the contract. So the fraud fails on many levels and for many reasons. And the problem here is really with the expectations of Mr. Raywall. That takes me to the counterclaim for breach of contract, where the defendant complains that the lease was breached by delivering the machines behind schedule, providing machines that were defective and unfit, not servicing the machines promptly, and not providing staff training, which no one's even talked about that, so I consider that abandoned. But as to the claim that the machines were delivered behind schedule, paragraph 8 of the contract provides, quote, seller will not be liable for any delay in the performance of orders and contracts or in the delivery or shipment of goods or any damages suffered by the buyer by reason of such delay when such delay is directly or indirectly caused by, and I'm leaving out some irrelevant verbiage here, transportation delays or any other causes beyond its control. Buyer indemnifies BBC against losses of any kind, including but not limited to product loss or loss of production. Either reason that's, end quote, either reason that's given for the delay, either Mr. Raywall's understanding of the delay in the machines coming or Mr. Furness's explanation, are reasons beyond plaintiff's control by their own description. So liability is waived for late delivery. For its breach of contract claim, for all of its claims that it's making as to how the contract was breached, the defendant is seeking lost profits stemming from loss of production. Those damages are waived by paragraph 8 that I've already described and by other provisions as well. And once again, if only Mr. Raywall had read the contract, he would have seen these provisions and maybe his expectations, although seemingly reasonable, would, on their face, would have proven unreasonable had he read the contract he was signing. So first of all, we've got paragraph 3. Quote, should any products prove defective or fail to meet the written specifications accepted by the seller, the buyer shall not return the goods, but shall notify the seller immediately, stating full particulars in support of buyer's claim, and seller will either replace goods upon return of the defective or unsatisfactory material or adjust the matter fairly and promptly, but under no circumstances shall a seller be obligated for consequential or other damages, losses, or expenses in connection with or by reason of the use of or inability to use products purchased for any purpose, end quote. That is applicable. There's just one argument I'll address very briefly. Obviously, that language refers to seller and buyer. The entire contract treats them as seller and buyer, so that is of no import whatsoever. Each party signed it as seller and buyer, even though it's actually a lease. So that paragraph 3 does apply. Also, paragraph 7, and this is the first 7, there's 2 7s in the contract. So the first 7 says, quote, no warranty or guarantee expressed or implied including any warranty as to merchantability or fitness for any particular purpose is made unless the same is specifically set forth in the attached sales agreement, and seller shall not be liable for any loss, I think it's supposed to be, or damage, directly or indirectly arising from the use of the product or for consequential damages. One need not claim breach of warranty per se in those exact words. And there's a lot of ors in that paragraph. It is applicable, and the defendant's claims for breach of contract simply fail for multiple reasons, but including damages for lost profits or lost production are expressly waived. I also have to address the claim that a new contract was made prior to the 2018 season. That claim is just clearly not true. The contract signed in 2017 provides for a 3-year rental. When the defendant didn't pay for 2017 and was dissatisfied with the equipment, the email exchange, Exhibit M, occurred, in which Mr. Fraser, F-R-A-S-E-R, and Mr. Raywall laid out their complaints about the plaintiff. On April 6, 2018, Mr. Fraser discussed some of the problems from the prior season and then proposed that the defendant pay $15,000 in 2 payments for the balance of 2017 and pay $129,000 that would be due in 2018 in 2 payments. He also wrote in the email, quote, "We also need to know that going forward, BBC will have enough service staff on the ground here in BC. We cannot afford to have a repeat of 2017, end quote. Plaintiff made a counter proposal on the payment due for 2017, cited terms of the contract regarding delivery and consequential damages being waived, and said, quote, TOMRA, capital T, all caps, T-O-M-R-A, in their acquisition of BBC, noted commitment to supporting BBC to find new ways to enhance local presence, after-sales support, and technology development. We have already started on maintenance of machines in the region, ensuring we will have greater bandwidth throughout the season, end quote. Mr. Raywall replied on May 1, 2018, that their previous proposal was firm and final. The rep of the plaintiff wrote back on May 3rd, quote, as per our conversation just now, we will progress with your suggestion, end quote. The defendant now claims that the agreement to pay was conditioned on a promise that there would be no repeat of the 2017 season. There might have been some fence mending that took place in what appears to have been a conversation between Mr. Furness and Mr. Raywall, but the Exhibit M, which can be the only thing because we all acknowledge any agreement has to be in writing in this situation. Exhibit M doesn't support that payment was conditioned on a promise that there would be no repeat of 2017 for 2 reasons. First, the lease agreement signed in June of 2017 had a term of 3 years. So the emails were not a negotiation of a new contract. Second, Mr. Raywall was already obligated under the lease to pay $129,000 for 2017. He was negotiating to pay only a fraction of what he already owed for 2017. The notion that he was agreeing to pay a fraction of a bill that he already owed if the other side agreed to do better in the future is just not tenable, and it's not consistent with contract law. Stated otherwise, you could say that even though if plaintiff was promising to do something for the 2018 season, and what was said doesn't really support a promise, but let's just say if plaintiff was promising to do something for the 2018 season, there's no consideration for such a promise because Mr. Raywall was only doing or agreeing to do what he was contractually bound to do in the first place. We would call that lack of consideration, among other things. So the defendant's motion for summary disposition on its counterclaim is denied. The plaintiff is entitled to summary disposition on counts 1 and 2 of the counterclaim. The plaintiff is also entitled to summary disposition on counts 3 and 4 of the counterclaim those are implied contract and equitable claims where there's an express contract between the parties, and so those are clearly not applicable. So the plaintiff's motion as to the counterclaim is granted and the counterclaim is dismissed, which takes me to the plaintiff's motion for summary disposition on the plaintiff's complaint, which is for breach of contract in count 1 and account stated in count 2. The plaintiff is asking for damages, although there's in the first amended complaint, there is this escalation of damages into $750,000 or more. What they've asked for in this motion is damages in the amount of $211,249.97. The defendant paid only $64,000 on the 3-year lease agreement that provided for $129,000 per year. The machines were repossessed before the 3-year period, leaving a balance owing of $144,000, which Mr. Raywall acknowledged in his deposition that he never paid. That includes the negotiated settled amount of $15,000 for 2017 and the amount of $129,000 for the 2018 season. The court, having ruled on the counterclaim and rejecting the defendant's claims of fraud and breach of contract, the only conclusion is that the defendant breached the lease agreement. The $144,000 was a negotiated and agreed to amount. An account stated is a contract based on assent to an agreed balance. An agreement to the balance doesn't have to be an express agreement. It can be done by either paying the invoice or failing to object to them within a reasonable time. Here, the defendant actually made an express agreement to the account, but also failed to object within a reasonable time. In the Exhibit M emails, Mr. Raywall expressly agreed to pay $15,000 for what he owed on the 2017 season that was already past due. And he agreed to pay $129,000 for the upcoming 2018 season, which was the contractual amount for the year. In the fall of 2018, Mr. Raywall was repeatedly invoiced for those amounts. Mr. Raywall, in his deposition, couldn't point to any time that he objected to the invoices. He either said that he did not reply to the emails sending the invoices repeatedly, or he could not recall. The invoicing continued from August 2018 to January 2019. There is absolutely no evidence that Mr. Raywall ever objected until mid-December of 2018, when he learned that the plaintiff's service staff were being pulled out of the area, presumably at that point because of non-payment of the invoices. Then he testified that was the point where he told Ryan Neville that he was not going to pay. That does not create an objection to an account. You can't ignore an invoice and even impliedly acknowledge it by ignoring it in August, September, October, and November, and then decide in December that you are objecting to it. The account stated was formed when the defendant agreed to the account for the 2017 season and failed to timely object to the invoices in August, September, October, and November for the 2018 season. The plaintiff is entitled to summary disposition on his breach of contract and account stated claims. Not clear still on the $750,000 issue. It was not part of the motion for summary disposition, but I think that at least on the account stated claim, the plaintiff is entitled to judgment in the amount of $144,000 plus the 18% interest that's contractually provided for. On the breach of contract claim, if they're still wishing to pursue these enhanced damages that I have serious misgivings about, then I would say that what they are entitled to is judgment on liability on the breach of contract claim with damages still to be decided. But that is my ruling. And Mr. Vernon, would you like to submit an order?
Yes, Your Honor, we can do that.
Okay, then that will conclude our hearing for this afternoon.
Thank you.
Thank you, Your Honor.